Okay, hello everybody. Hello. I'm just getting everything set up here. I'm running just a little bit behind tonight, so it's going to take me just a minute. But good to see you all. Hello. Hi, Jen. Good to see you. Good evening. Hello, Jennifer. Hello. Whew, okay. Here we go. Yes, okay, right. So, let me see where the order is that I found. All right, are you talking about the dismissal? Is that what you're talking about? Yeah, there's been a lot going on. It's been a lot. There's been a lot of updates. So, yes. All right. Yeah, are you Steffi, are you talking about the appellate decision that just came out? Let me just make sure. Trump said he would not ask for a federal trial. Right. Hello, Hawk. Hello, good to see you. Welcome, everybody. Yeah, it's been a lot. We've had a lot of things going on here for sure, which has been very interesting situation. He wants TV. Yeah. Yeah, I think that's very interesting. Like, you don't really hear that very often from defendants. Yes, anti-candy corn video. No way. That's funny. Oh, goodness. Okay, here we go. Oh, I'm just a little bit behind on everything today, I'm afraid. It's been one of those days, but that's all right. We will make it through. Yes, candy corn's out. Oh yeah, the plane. I've heard some people posting about that. I really don't know what's going to happen with that. I'm not sure how that's listed as an asset. I really don't realize, I don't know how his assets are going to be divided. But what a mess. What a mess that New York situation is. My goodness. Sitting in court is under oath with a lie detector. That's funny. I got Halloween blow pops and they're rather... Oh, really? Oh, yeah. That's interesting. You know, I have to say, like today, my special treat was I found a strawberry. It's very rare to actually find a strawberry one. So this is my special treat. I'm so excited about it. It's the little things, you know? It's the little things. Yes, I've got, kind of a mixed bag. Can you put the picture up so we can... Yes. Oh, we haven't done the elephants in a while, have we? It's been too long, everybody. Here we go. Don't be afraid. Here we go. Here's the picture. Oh, let me get it centered a little bit better. There we are. You got the picture. Yes, we've got so many things going on right now. We've got Eastman's California bar situation is still going. We've got Powell and Cheesebro heading to court in a couple weeks. So we've just got a lot. And then Meadows has his appeal going still. So yeah, there's really quite a bit going on here with everybody. Make the bad man go away. I know. That's so funny. Oh my goodness. Yes. So let me take you through here. We've got our fake electors here. We've got an attorney here. This attorney, his license is under fire in California, so we've got that going on. Oh no, the shenanigans. Oh, we love the shenanigans. So, Giuliani's lost his license, I know for sure. He's also had some defamation suits going on in New York, so that's been going on for him. Powell and Cheesebro head to trial in Georgia in just a couple weeks. They've got motions and things going on this week and next week. We have Latham Still and, and Schaefer. Those three had tried to move to federal court, so that's not been successful at this point. Floyd has filed some motions to try to get election information released, so private election information. He's put a motion in for that. That hasn't happened yet. We've got Meadows with his multiple briefs and motions going on as well. And then Cuddy's down here, still smiling. And so that's about it. That's the update from here. And then, Clark's also got a lot of his motions as well. So everyone's been pretty busy. Ellis doesn't have much filed, and neither Hampton doesn't have anything filed. So she hasn't filed anything as of this point yet. So yeah, it's been busy. It's been a busy It's been a busy few weeks here for sure. Oh, there's the elephant again. Oh my goodness. It's funny every time. He'll not be able to sustain the financial cost of legal and campaign costs. Well, it's a good question. I mean, he can continue to campaign and use campaign funds to try to pay for his legal expenses out of his political action committee. So that is kind of an ongoing situation. But, I'm not sure how long people are going to continue to want to do that. So, yes, I think you have to laugh, user 9301. I think it's important to laugh in your life, even when things are serious and they're not looking great. I think if you remember to laugh, you'll be able to make it through to the next day. Can you put a mark next to each one that loses their license or gets convicted? Yes, I could do that for sure. I will keep track of that. Right now we have Meadows, Clark up for grabs still. Eastman's up for grabs. So we will see. I'll need to go through that, but I'll make a special mark just for those who have lost their license for sure. Yes. So we've got a lot going on here. I've got several things I can go through tonight. So I wanted to kind of see where everyone was really kind of wanting to go. I do have the Mark Meadows brief for the appellee for the state of Georgia, right? So he's continuing to try to appeal to get his case moved. So we have his First Amendment arguments and so on. That's been filed. But something else that I thought was very interesting is that in the Florida, let's see. I get the cases mixed up. Hold on here. This is Georgia. Just a minute. Let me make sure I get the right case with the right jury. So we had in Florida, Trump had made a motion to revise the schedule for motions and to compel different litigation. So he had put that on file on the 22nd. So that came out in Florida. So this is a Florida filing. And then we've got the government's opposition to his motion for a revised schedule. And this opposition just came out yesterday. So we've got that kind of in the waiting wings for Florida. And then here we have in Georgia on the 25th, an order restricting jurors' identity. That just came out of Georgia, along with the potential for conflicts of interest. Now, this was filed on the 20th, and I've just printed out the first few pages going through the attorneys and what Georgia's claiming are conflict of interest. So I wasn't sure where everyone wanted to start tonight. But we've got a lot of good stuff here. Yes, I did Judge Chutkan's response last night to the motion to recuse. Yep, we went through that. She did a really good job, I thought, of going through and explaining her rationale for why recusal wasn't appropriate in this situation. So she did a really good job. The Georgia conflict might be interesting. Yeah, I think so. Do you post it on YouTube? I am up to date on YouTube except for last night's. I've not posted last night's yet. So that will be posted. I'm posting about every 12 hours. Things are a little different on YouTube, so I can't post a whole bunch all at one time. But another fun fact, Trump trial in Atlanta will be televised. Court remains in... Yes, not federal. Yes, I did see. It's huge news, Stephanie. I mean, that's really huge news. How many do you have tonight? Well, I have a couple. So, and I've got, I missed the live comments on YouTube. Yeah, I agree. I've got something I'm working on right now. So I'm hoping to start doing, once a week for sure, doing a live stream back on YouTube again. That'll start very soon. So, that will be going up soon, but, yeah, Blanco, I don't just have that at my fingertips, I'm afraid. Sorry about that. So here was that, and then we did have the New York case as well. So, yes, off topic, but your nails look pretty. Oh, thank you. Thank you so much. Yeah, we've got a little bit different color tonight, so... Platinum, really? That's interesting. So I guess we could start with, do we want to do Georgia or do we want to do conflict of interest in Florida? So that's really, where we want to start. I'm down for anything. Okay, so let's take a look then. I guess we haven't really done, okay, Georgia. Got it. So I'll put Florida to the side again, just kind of an idea of what we can start with and then move on from there. But so we had a couple of things going on in Georgia recently. Yeah, there's lots. There's a lot going on. There really is a lot. So let me just get the calendar out so we can all stay up to date on everything. Oh, goodness. All right, so this week in Georgia, which is in green, we had all motions that are not motions in limine due for Chesebro and Powell. Those were due the 27th. Then we had Meadows' reply brief for his appeal due. So I have his brief here, so we can go over that whenever we're ready. And then on Friday, we have the case management pretrial motions are all due by 9 a.m. Again, we're preparing for a speedy trial that's set to go the 23rd of October. So this is Chesebro and Powell going to trial here. Now, next week on the 6th, everybody in Georgia has their initial discovery due. So those first parts of discovery will be due in Georgia next week for everybody, not just Chesebro and Powell. So that's where we're at with the trial calendar. So the most recent motions that have been filed that are in Georgia right now, we have first an order on the state's motion to restrict jurors' identity. So a while back, the state filed a motion regarding preserving the identity of the jurors, right? So this was filed September 6th. So this order was set out September 25th. So I thought I would take us through that. And I'm going to go ahead and write down what this is. So I think, although it's really got the name on it. Hold on. One moment, please. Let me flip to the other side. Yeah, I think we'll be okay if I don't write it down. But I'll try to make sure I write down which documents they are. So let's go ahead and get started. Again, this order was filed on the 25th of September, and this is in response to the state's motion to restrict the juror's identity in Georgia. All right, so having reviewed the state's motion to restrict jurors' identity filed September 6th of 2023, The media interveners' opposition to state's motion to restrict juror identities filed September 15th, and the amicus curiae, or amicus curiae, filed on behalf of the Reporters Committee for Freedom of the Press. The court hereby grants in part the state's motion and orders as follows. So first, no person shall videotape, photograph, draw in a realistic or otherwise identifiable manner, or otherwise record images, statements, or conversations of jurors, prospective jurors, in any manner that would violate the Uniform Superior Court rule, except that the jury foreperson's announcement of the verdict or question to the judge may be audio recorded. Second, prospective jurors shall be identified by number only in court filings or in open court during the pendency of trial. No party shall disclose during the pendency of the trial any juror or prospective juror information that would reveal a juror's identity, including names, addresses, telephone numbers, or identifying employment information. Further, no party shall disclose during the pendency of the trial any list of jurors or responses to juror questionnaires provided to the parties, juror strike sheets, or any notes containing identifying information of jurors or prospective jurors unless permitted by the court to disclose such information. So this again is just this blanket kind of protective order for any of the potential jurors out of Fulton County. So again, this order was filed by the judge on September 25th. So then if we go back a week, then this is one order or notice that I have not gone through yet in a live. So, yes, Caleb, it will affect it, only that they have to be careful about how they are televising it, which they would have done anyway. So this is just kind of reiterating that. Love your black nails. Oh, thanks. Can you move the document down a little bit? Sure. Here we go. Top couple of lines are being cut off. Sure, you bet. You bet. Of course. All right. So this is the next major document here to go through. Yeah, I think my camera's just a little bit further down than usual. So I'm just trying to keep it in line. Yeah, Lemonade Crew. I got it. Oh, that's so funny. I still think the jurors should be behind a screen. Yeah, I think so. You've updated the app. It makes a difference. Oh, it does, Steffi. It really does. It's good. Okay, good. So again, I don't have the full notice here, but I think this is important because the state of Georgia has said, look, we've got some conflict of interest going on in Georgia. We want to bring it up. So here's our defendants listed out, and then they've made a list as well of the attorneys with their conflict of interest issues going on. So I thought we could kind of walk through that. You know, we have a similar situation going on in Florida right now with the Garcia hearing and some conflict of interest, but this one is for Georgia. So comes now the state, let's start at the very beginning up here. Notice of potential conflicts of interest concerning attorneys. And then the different attorneys have been listed out here. So we have this one, we've got Clark, Palmer, Grubman, McDougald, Morris, and Samuel, who previously represented defendants or witnesses for the state of Georgia pursuant to Georgia Rules of Professional Conduct, Rules 1.6, and so on. Very similar to what's happening in Florida as well. So comes now the state of Georgia by and through Fulton County District Attorney Fonnie Willis, and notifies the court of potential conflicts of interest concerning attorneys Mr. Anelwitz, Clark Palmer, Robert Grubman, this guy, and this guy, who each previously represented defendants or witnesses for the state of Georgia in this matter. The state requests that the court inquire into the circumstances and take such appropriate remedial measures as is deemed necessary to ensure that the rights of both witnesses for the state of Georgia and the defendants in this case are preserved in accordance with these set out rules. So since I've gone ahead and turned the page, let me go ahead and write down the document I'm going through here so that we don't have any questions later on. So we have the Georgia, and then we have the state presenting conflicts of interests. So I'm just writing this down on a sticky note so I can kind of keep it going. So this is a notice, and it was filed the 20th. Here we go. All right, there we go. So we can kind of follow along as I read through. Again, I don't have this full document, but it kind of gives us a good idea of what's going on. So I'll go ahead and just put this up here. Okay, so let me pull my document back down again. I'm trying to figure out the best format here for everyone so everyone can see it okay. Hello, the captain. You survived. Congratulations. Well done. Well done. All right. So let me just set this here. This is the Georgia conflict of interest, and I'm going to go ahead and dive right back in. Introduction. The Georgia rules of professional conduct state that a lawyer shall not represent or continue to represent a client if there is significant risk that the lawyer's own interests or the lawyer's duties to another client, a former client, or a third person will materially and adversely affect the representation of the client. I'm just going to move this down a little bit just to make sure everyone can see it okay. Again, I'm trying to figure out the best way to keep everyone up to date on what I'm reading here. So there we go. The client consent is not permissible if the representation includes the assertion of a claim by one client against another client represented by the lawyer in the same or substantially related proceeding, or if the representation involves circumstances rendering it reasonably unlikely that the lawyer will be able to provide adequate representation to one or more of the affected clients. So again, we have this issue that some of these attorneys have represented other people in the past. Next, where the conflict is such as clearly to call into questions the fair or efficient administration of justice, opposing counsel may properly raise the question. The prosecutor has the responsibility of a minister of justice and not simply that of an advocate. This responsibility carries with it a specific obligation to see that the defendant is accorded procedural justice. In light of the prosecutor's public responsibilities, broad authority, and discretion, the prosecutor has a heightened duty of candor to the court and in fulfilling other professional obligations. So she's setting out that she's got an obligation as the prosecutor to make sure that she raises any conflict of interest issues that she sees, and so that's what she's doing. Accordingly, as set forth below and in conformity with the Georgia Rules of Professional Conduct and relevant guidance related to the ethical duties and obligations of prosecutors under applicable rules, statutes in both the United States Constitution and Georgia Constitution, the state of Georgia is compelled to notify the court of potential conflicts of interest concerning attorneys Anulwitz, Clark Palmer, Grubman, McDougall, Morris, and Samuel, who each previously represented defendants or witnesses for the state of Georgia in this matter. The state is so compelled not only because it's paramount to the district attorney as a minister of justice must guarantee that the constitutional and statutory rights of all persons are preserved at every stage of a criminal proceeding, but also because the state's failure to do so would be fundamentally at odds with every lawyer's duties as a representative of clients, an officer of the legal system, and a citizen having special responsibility for the quality of justice. All right, so let's see if she will go a little further. So we've got procedural background. Between May 2nd of 2022 until the issuance of the final report on December 15th of 2022, a special purpose grand jury convened in Fulton County, Georgia, to investigate facts and circumstances relating directly or indirectly to possible attempts to disrupt the lawful administration of the November 3rd, 2020 presidential election in Georgia. Order, and then we're doing Exhibit A, order approving request for that throughout the course of its investigation, the special purpose grand jury subpoenaed evidence and heard testimony from as many as 75 witnesses, most of whom were represented by counsel. During roughly the same time, the state of Georgia also conducted voluntary interviews with many of these and other witnesses represented by counsel. Counsel for these witnesses served a variety of purposes. Some simply acted as logistical liaisons between their client and the state. Some negotiated the scope of their, flipping the page here, we're about to get into the names in just a minute. So, client's testimony. In the context of certain testimonial privileges, some moved to quash subpoenas and engage in other related litigation on behalf of their client, and some obtained immunity from prosecution for their client in exchange for testimony or interviews. In the months following the November 3rd, 2020 presidential election in Georgia, many individuals who later became witnesses involved in or subjects of the special purpose grand jury's investigation engaged in private litigation related to that election. That litigation in both states and federal courts included lawsuits against Georgia Governor Brian Kemp, Georgia Secretary of State Brad Raffensperger, members of the Georgia State Election Board, and other government officials. There was considerable overlap in the subject matter, witnesses, parties, and attorneys involved in both the special purpose grand jury's investigations and many of these lawsuits. On August 14th of 2023, a separate grand jury in Fulton County, Georgia, heard testimony, reviewed evidence gathered by the state, and ultimately returned the indictment in this case, charging 19 defendants with 41 criminal violations of the law of this state. Let me just bump this up here so I can just keep going. In the days following the return of the indictment, all 19 defendants secured representation by counsel, many of whom had previously been involved in the special purpose grand jury proceedings, private post-election litigation, or both. Since the return of the indictment, the state has worked diligently to identify any potential conflicts of interest concerning attorneys who currently represent defendants in this case, and who previously represented material witnesses or parties before the special purpose grand jury and other post-election proceedings. Okay. Here we go. Number 3, prior representation of defendants and witnesses for the state of Georgia. The following is, to the best of the state of Georgia's knowledge and belief, a list of the attorneys in this matter who previously represented defendants and material witnesses or parties before the special purpose grand jury and other post-election proceedings. All right, so now she's going to go ahead and take us through the attorneys and the conflicts that she's seen. So, again, I don't have this entire document set out. It's enormous as we go. So, yes, I am having a great day. Thank you for asking. Yes, it's been a great day. Let me just bump this down again. I've got to make sure I'm in frame here. All right, here we go. Number 1, let's talk about Christopher Scott Newlewitz. Am I saying that right? I don't know. I may be saying his name wrong. Hold on a minute here. Let me just bump my camera up just a little bit so I'm in frame better. There we go. How is that? Is that better, everybody? Let me just make sure I'm in frame. Good. Okay, thanks, Frank. Thank you. Yeah, better. Okay, good. A Newlewitz. Okay, thank you. Okay, excellent. Great. Yes, so this is the Georgia, now the government or the state of Georgia here is filing a notice on potential conflict of interest regarding several attorneys involved in the case. So I'm going to take you through the attorneys and what she's claiming are the conflicts or the notice of conflict. So it'll be up to the judge eventually and the defendants to decide if that conflict is too much that needs to be repaired or fixed, but we'll see. So the first one, this attorney, Newlewitz, I think. Hopefully I'll say that correctly. Filed an entry of appearance as counsel of record for defendant Robert Cheeley. So let's pause for a moment and keep everybody straight here. Let's make sure I get this right. So, okay, here's Cheeley right here. So this is Cheeley. There we go. Don't be scared. Sometimes the picture will just come up, people. So here we go. Here's Cheeley. So, right. Mr. Newlwitz, sorry, previously represented Georgia's Secretary of State Brad Raffensperger and members of the Georgia State Election Board in Trump v. Raffensperger, Fulton County Supervisor Court case. Respondents replied to petitioner's objection in Exhibit C and D. So response to plaintiff's notice of filing voluntary dismissal. So she's citing the different times this attorney, who's now representing Mr. Cheeley, had been representing Brad Raffensperger, okay? So the answer filed by this attorney in this matter has been sealed, but the preceding exhibits demonstrate his involvement in the matter from the beginning to the end. Georgia Secretary of State Brad Raffensperger, members of the state election board, and this attorney himself are witnesses for the state in the present case. Whoa! So let's take a moment there. So we have an attorney here who is also a witness for the state. So I'm not sure if that is too much of a conflict. I don't even know of an attorney representing a defendant where he's also going to be a witness against that defendant. That might be an issue. Yeah, exactly. Wow, that's significant. That's a pretty big issue. His former clients would be subject to cross-examination by him were he to remain counsel of record in this case. That's huge. That's a huge one. All right, so we've got an endnote here. Let's bump down here. So Mr. Newlwitz is a witness because he represented Georgia Secretary of State Brad Raffensperger on January 2nd of 2021 when the defendants Donald John Trump and Mark Randall Meadows, along with the attorneys representing the Trump campaign, placed a telephone call to Secretary Raffensperger without making Mr. Newlwitz part of the telephone call. Attorneys representing the Trump campaign later characterized the telephone call as a settlement negotiation in court filings, and Mr. Newlwitz is a witness to, among other things, the fact that that telephone call was not a settlement negotiation. So that's pretty significant. What do we think about that? I'm thinking Mr. Newlwitz may be out. Mr. Cheeley may need to find different counsel. That's pretty significant. If he was actually Brad Raffensperger attorney, that's a pretty big deal. Yes, it's like a Garcia hearing, Janet, only this is in Georgia, so we don't call it that, but it's pretty much, it's putting the notice out so that a hearing could be put together if needed. Yep, refund the retainer. All right, well, that one seems pretty significant. Seems like he's out. Yeah, I would agree. What lawyer in their right mind would take this case? That's a great question. But, everybody has a right to counsel. So, all right, number 2. Let's get into the next one. Here we go. Amanda Rourke Clark Palmer. I'm going to just completely butcher these names. I apologize ahead of time. Apologies. All right. Attorney Amanda Rourke Clark Palmer filed an entry of appearance as counsel of record for defendant Ray Stalling Smith III. So let's get out our visual aid. So Ray Smith III is this guy. He's an attorney who got dinged here. So that's who she's representing. Now, Ms. Clark Palmer previously represented Sullivan Strickler, LLC, during the special purpose grand jury investigation. Do we remember Strickler? Sullivan Strickler? Does anyone remember that company? Yikes. In Exhibit F, email titled Sullivan Strickler Follow-Up, Miss Clark Palmer also previously represented former Georgia Lieutenant Governor Jeff, oh, this isn't looking good, Jeff Duncan, and other members of the Georgia General Assembly during the special purpose grand jury investigations. So she's bringing up the motion to quash subpoenas. So Sullivan and Strickler, former Georgia Lieutenant Governor Jeff Duncan, and members of the Georgia General Assembly are witnesses for the state in the present case. So I think this is helpful too in assessing who's going to be called as witnesses. We don't have a full witness list at this point. We will soon, but she's already setting out here some of these witnesses. So we've got members of the Georgia General Assembly who are going to be witnesses, along with the former Georgia Lieutenant Governor. So that seems like a conflict. Miss Clark Palmer's former clients would be subject to cross-examination by her, were she to remain of counsel of record in this case. So what do we think? Too big of a conflict? Is that that seems like a pretty major one. Yeah, more lawyer witnesses. Exactly, Suze. Exactly. Yep, she's gone. Yep. This one's a pretty significant one if they've got so many witnesses that she's already represented. I want your highlighters. Oh, thanks. Yeah, no, I thought these would be helpful because you can see through them when you're highlighting. So, yep. Me in an office supply store. Sounds like a conflict. Yeah, sounds like one to me too. I mean, geesh. All right. Let's go to the next one. Number 3, Scott Robert Grubman. So on August 16th of 2023, attorney Scott Robert Grubman filed an entry of appearance of counsel of record for defendant Kenneth John Cheesebro. Uh-oh. Cheesebro's supposed to go to trial in a couple weeks. So this guy, oh no, if his counsel has a conflict, that could be a problem. Yikes. I'm worried. I'm worried for Cheesebro. See Exhibit H, entry of appearance. Mr. Grubman previously represented Georgia Secretary of State Brad Raffensperger. Oh no! And Patricia Raffensperger during the special purpose grand jury investigations. What? That's not right. That's not right at all. She's citing Exhibit I and text messages in Exhibit J, the LinkedIn post. So Georgia Secretary of State Brad Raffensperger and Patricia Raffensperger are witnesses for the state in the present case. Mr. Grubman's former clients would be subject to cross-examination by him were he to remain counsel of record in this case. Whoa, that's really bad, right? I mean, I guess, if everyone agrees to it, that's still potentially okay, but that seems like a pretty big conflict of interest. Also, did anyone know that Brad Raffensperger's wife, Patricia, was going to be a witness? Did anyone know that? I didn't realize she was going to be a witness. I'm not sure what role she played. How do they not know their own conflicts? Yeah, it's a good question. I mean, maybe again that they're not fatal conflicts, so I mean they can be fixed, but she got threats. Okay, sure. Maybe told her about it right after it happened. True, although that would be some pretty hard hearsay to overcome in that situation, but possible. Never heard anything about his wife. Yeah, I haven't either. But both of them were represented by the attorney for Cheesebro. You guys remember we watched him. He's the lemonade guy. So Mr. Lemonade. Yeah, that's questionable. Yeah, that one's definitely suspect here. Suspect. Yeah, the lemonade guy, the motion in lemonade, which, that's fine. Who knows how to pronounce? Yes, hydrate. Oh, thank you. Yeah, for reminding me. I have tea tonight, actually. Oh, my goodness. These are huge conflicts. Yikes. He's cheese of cheese and crackers. Exactly. You got it, Ree. Bathing in lemonade. This case is like, it's true. Yikes. Okay. So this looks pretty significant. It Mesa. I thought you were doing the Spanish for mess. Oh, my Spanish is terrible. Okay, here we go. Number 4, Harry McDougal. So, on August 25th of 2023, attorney Harry W. McDougal filed an entry of appearance of counsel of record for defendant Jeffrey Bossert Clark. All right, let's get out the picture, everybody. Be prepared. Don't be scared. Here we go. So Mr. Clark, the one that continues to file to get up into federal court, back down, back and forth, Clark and Meadows. So this is also, so Mr. Clark here. So let's see what conflict we have here. I'm concerned at this point because that's pretty significant. Yeah, jump scare. Sorry about that, Austin. Sorry. All right. So entry of appearance, right. Ooh, here we go. See Exhibit K. Entry of appearance, Mr. McDougal, defendant Sidney Catherine Powell, and L. Lynn Wood previously represented Correco Jaquan Pearson, Vicky Townsend Consiglio, Gloria K. Godwin, James Kenneth Carroll, Carolyn Hall Fisher, and Kathleen Alston Latham. Whoa, that's a lot. So, that's Miss Latham there. Whoa, that's a lot of conflicts here. In Pearson v. Kemp, this is the Georgia governor case, and the certificate of interested persons, the state is not attaching the complaint in the matter because it is 104 pages in length. The state can provide the complaint to the court upon request. That's pretty significant. On Consiglio, no, VC, I have not. I've not taken a look. You'll have to, let us know what's going on with that. No, I need to. I'll probably spend a live going through that. I glanced, but haven't been able to really pull it apart yet. Not enough hours in the day, people. What's Exhibit K? Exhibit K is an entry of appearance of counsel. So that's just the document saying that they're appearing as counsel for Mr. Clark. Now, what they're saying here is that there has been previous representation of Ms. Powell, who's a defendant, Wood, who's a serious witness, and then multiple other people who have been charged or are witnesses. And she's naming here. So we've got Lynn Wood, Correco Jaquan Pearson, Vicky Townsend Consiglio. Again, these I think are the ones that were at the fake electors meeting, right? They're the ones that were at the Republican situation that was recorded in the transcripts. Is that right, everybody? That's right, isn't it, VC? Yes. Okay. Got it. Right, don't have it firmed up. Yep. Gloria K. Godwin, James Kenneth Carroll, and Carol Hall Fisher are witnesses for the state in the present case. So I think at this point, this is Georgia. Georgia filed this notice of conflict of interest. So let's take a minute and highlight more people that we know then are going to be witnesses. So this is helpful in determining who the state plans to call. We have Pearson, let's see, Vicky Townsend, I'll have to read up on that one, Gloria K. Godwin, James Kenneth Carroll, Carolyn Hall Fisher. So these are all state witnesses. So all of them must have given plea agreements. You have your computer, you can pull up that spreadsheet for the notes to use. I could VC. I'm looking across the room at it. Hold on. I may need to go back. All right. Hold on. So all of these are, if you want to or can. Yeah. So why don't, hold on for 1 minute, everybody. Let me go see if I can pull that spreadsheet up real quick. Just 1 moment, please. Okay. Be ready. I'm not trying to jump scare you, but here you go. This will be my, stay tuned for broadcasting in just 1 moment. Here we go. Okay. Thank you for your patience, everybody. Okay. Hold on. Here we go. Oh my gosh. You did. VC. This is amazing. Oh my gosh. Whoa, this is amazing. Okay, so this is a lot of really fantastic information that we have here. Okay. So, GOP Assistant Treasurer since 2019. Okay. Got it. All right. That's really great information. I'm going to need some time to go through that, though, to really get the full impact. I will process that and put that together. I think it'll be worth going through on a full live on that. Way deeper than we thought. Yeah. Oh my goodness. Oh my gosh, the hat's back. Okay. That looks amazing. Your spreadsheet looks fantastic. I will put it through. I have a special app that I need to use in order to get all the information out. But let me put it together, and then I think we can do a live on it. Why is the DA listing witness conflict? Sure. So here we go. As is required in any state, if the government thinks that there are conflicts of interest, then they need to bring them up to the court. So that's what she's doing in this case. She's saying, hey, we had this special grand jury pulled in. We had all these witnesses. Now we know that some of these attorneys represented these witnesses and are now representing some of the defendants. And so we see conflicts and we're telling the court about it. She's one of the kind that does those gala fancy dinners. Really? Okay. Love that. All right. Yeah, VC, that's amazing. I'm going to have to process more of that so we can go through that. All right. So that's a pretty big deal. Thank you, everybody, for hanging out while I double checked on that. Yeah. So I think we've been talking about this one. And so she's got a lot of information. Hello, Greg. Welcome back. So she's got a lot of information. She's really got, oh my gosh, VC, it's amazing. Yeah, I'll need to process it. I've got to put it through a special program, but I see Linwood. Yes. So what they're saying is the attorney then representing Clark, let me make sure I have the right person, representing Clark has also been represented these other witnesses that they're planning to call. So even Powell also, who is another defendant, and Latham, who's another defendant. So Mr. Dugald, also previously represented and was co-counsel to L.L. Wood. Now, of course, we know L.L. Wood is another significant player here and was named in this lawsuit. And this is the U.S. Supreme Court case number 20-799. Petition for writ of certiorari cover sheet. L.L. Wood is a witness for the state in the present case. So we've got confirmation that Wood is going to be a witness for sure for the state. So that's pretty significant. Mr. McDougald's former clients and co-counsel would be subject to cross-examination by him were he to remain counsel of the record in this case. So he's got huge, yeah. Frank, you're like, yep, looks like a conflict. Yep, I agree. That's pretty significant conflict. Pretty significant. All right, so each one of these has some serious conflicts. All right, so Bruce H. Morris. On August 22nd, attorney Bruce H. Morris filed an entry of appearance as counsel of record for defendant Ray Stallings Smith III. All right, the conflict board is growing. That it is. All right, so don't be scared. Here we go. Here we've got one more. So Ray Smith III. Do lawyers not have ethical requirements to let their clients know of conflicts? They do. Will the potential attorney interest conflict result in case delay? At this point, The only one that I can see that would be a problem would be Cheesebro, because he's set for speedy coming up in a couple of weeks. But other than that, the rest of these, we don't have a firm trial date. We don't know how long it's going to be. So I wouldn't say it would delay anybody else. I would say the only one is the one for Cheesebro, and then this issue here for, cheeseburgers. And this Powell, who was one of the witnesses or one of the defendants. Oh, thank you. Thank you so much. So I don't see this being a delay. And also, this motion was filed on the 20th, so they've already been given notice. So we do have some notice already. Now, when it comes to ethical obligations, with conflict of interest, there are ways to kind of mitigate the damage that can be done with conflicts of interest. Like you can kind of isolate people in your firm away from the defendants. So it's going to depend on what the role is going to be with their previous their previous clients versus their current clients. Now, in some of these situations, the court may say, yeah, there's a conflict, but we don't think it's going to be detrimental to anyone, so we can go forward. That's possible for the court to do that. With the shutdown, does this give delay? No, it doesn't. Nope, we're good to go, Becky. We're good to go. What about privilege? Privilege is another thing. The privilege would need to be upheld by the attorney. So it would be the attorney's responsibility to not state or include any privileged information in anything with their current client versus their previous client. Cheesebro's toast with or without a conflicted attorney. Yeah, he's got, cheese toast. I was hoping it delayed it. Yeah, nope, I don't think so. I don't think it's going to delay Cheesebro and Powell. I think they'll take care of it. The judge seemed pretty firm about this October date. So, and then there should be plenty of time because the second trial's not been set. So, all right. So Ray Stallings Smith III, Mr. Morris previously represented Paul Maggio during the special purpose grand jury. So, in an email titled Sullivan Strickler Follow-Up, Paul Maggio is a witness for the state in the present case. Mr. Morris's former client would be subject to cross-examination by him were he to remain counsel of record. So this would be an example that, depending on how his representation went, it may not be detrimental. It may be a conflict, yes, but it could be waived if all parties agreed to it. This would be an example of it. I don't know about these other people, though. That would be a pretty major conflict. But this one with Bruce Morris, this would be an example of how he could still be allowed to represent Mr. Smith here. Can we please call him Cheeseburger? Oh my goodness. Cheeseburger. All right. Oh my gosh. Donald Franklin Samuel. On August 20th, attorney Donald Franklin Samuel filed an entry of appearance as counsel of record for Ray Stallings Smith III. So now Morris and Smith have both filed as appearance as counsel for him. Mr. Samuel previously represented former Georgia Lieutenant Governor Jeff Duncan and other members of the Georgia General Assembly during the special purpose and jury investigations. This could be a lot. Mr. Smith also previously represented Keith Williams during the special purpose grand jury investigation. Again, we're just basically getting the names of a lot of the state's witnesses here, so that's very helpful. Again, we've got the former Georgia Lieutenant Governor, Duncan, and other Georgia General Assembly people. Yikes. This one could be too much of a conflict. Again, I'm not sure, but I could see how it could be. So, investigative interviews. Also, in an email titled Keith Williams, former Lieutenant Governor Jeff Duncan, members of the Georgia General Assembly, Keith Williams are witnesses for the state in the present case. Mr. Samuel's former clients would be subject to cross-examination by him were he to remain of counsel of the record. So, and then I didn't print out all the rest of this because she's just going through the rules regarding conflict of interest. So I didn't think that would necessarily be very helpful. But I thought this gave a pretty good overview of those attorneys that she's naming, that she's saying, look, we've got conflicts of interest going on. And I think she might be right. I mean, at least in 4 of them, those are some pretty significant conflicts. naming here for conflicts. Let me just list their names out again. Let me see, where did their list go? Oops. Here we go. We have Christopher Scott Anulwitz. Here, let me just highlight these names. We've got Clark Palmer, Grubman, McDougald, Morris, and Samuel. So Morris and Samuel both have conflicts with Smith III. So that's interesting. That's some interesting information that we didn't have before. And again, this was filed on the 20th of September. Are there any attorneys left in Georgia? I don't even know. I mean, could there be? I don't know. There's a lot of attorneys listed here. Oh, that's a lot. It really is a lot. It really is. It's a lot. All right, so that's the conflict of interest questions out of Georgia. So then that takes us to a case, and we haven't really talked about Florida very much lately. Now, I've got, again, this Florida opposition to the motion for a revised schedule. So Trump has asked for a revised schedule regarding the Florida case. Now, this is the one that seems to be keep getting pushed back and back and back. So we do have the opposition. This was filed on the 27th. Georgia's a lot. I agree. Georgia really is a lot. What does this imply? It implies that they're going to have to figure out whether or not these attorneys can remain representing the defendants. And I'm not sure if they will be able to or not. Florida home state. Yay! That's fun. Oh my gosh. Okay. So before I move into Florida, though, let me just show you again where we're at in Florida. I think a lot of times we forget about the Florida case because it's so slow moving, but it's still an important case here. So in Florida, we had supplemental briefs that were due on Monday, and then we didn't have anything else for September. Now, the SIPA challenges are due. Now, again, we've got confidential information involved with the classified documents. So they have to have special hearings regarding what the jury can hear, what kind of clearance people can have, and the documents. So we've got special hearings regarding all of those privacy issues. That's what's going on in Florida. Now, on the 12th, we have the Garcia hearing, which is similar to kind of what we just talked about here in Georgia, where we've got a witness for the government who was previously represented by the same attorney as one representing one of the defendants. So the Garcia hearing is going in and investigating whether or not that conflict is going to mean new counsel needs to be brought in or not. So that's what that Garcia hearing is on the 12th. And so then we've got another hearing again on the classified documents, and then discovery also is due the 20th. So what this motion is here is we've got the schedule set out that the judge set out. Judge Cannon had already put together, and Trump had asked for a revised schedule regarding the motions to compel and the SIPA Section 4 litigation. So that's the first thing. Again, this is because of the special classified documents element involved here. So he's requested a change in the calendar, and then now we've got the government's response. Think they're delaying Florida to make the schedule easier for the rest? I don't know. I think it's just how this judge wants to run her court, really. I think that's really the big piece of it, is this is how she wants to set her schedule. Trump's already asking for the schedule to be changed, even though she said it months ago. So, I think she's just taking her time. I don't think she really is thinking about the other jurisdictions, not as much as the other ones are probably thinking about her, I guess, is how I would put it. All right, so because we haven't visited in Florida in a while, let's go ahead and go through this. This should give us kind of another overview of what's going on so we can keep up to date with what's going on in Florida. Rocket Docket State. Yeah. Well, it certainly doesn't seem to be in this particular situation. So, all right, let's dive in. Let me just make sure I've got the correct label on this document. This is the government opposition to Trump's motion. Opposition to Trump's revised schedule. All right, I'm just writing a sticky note out here so we can keep track of what document we have here. And again, this was filed just yesterday. So this is the most recent filing out of Florida. It's hard to keep them all straight sometimes, I think. So we'll do our best. We will do our best to make it through with the complicated trial schedule that's going on in our worlds right now. All right, let me just make sure I'm in frame okay, and then I'll go ahead and get diving right in. Yeah, so this is written by the government. So this is the government's response to Trump's motion. All right, so let me just remind everybody, we have Trump who filed his motion on September 22nd, asking for a revised schedule for motions to compel in the SIPA litigations. Again, these are the Classified Information Procedure Act special hearings because of the documents. So he's asking for a revised schedule, and this is the government's response to that request. All right. So let me go ahead and get diving right on in. Opposition to Trump's motion for a revised schedule. In light of brief delays in the entry, the SIPA Section 3 protective orders and defense counsel read-ins to certain compartments, the court invited the defendants to file a motion to extend deadlines related to SIPA Section 4. Instead, defendant Donald J. Trump, joined by his co-defendants, filed a motion that threatens to upend the entire schedule established by the court, and that amounts to a motion to continue the May 20th of 2024 trial date. So we don't want that. I've already got that written on my calendar. I wrote it in pen. I don't want to have to change that. So here's an end note. Trump also filed a classified supplement to the motion. As the government is not disclosing classified information in its opposition, the government is publicly filing this response to both defendants' motion and Trump's classified supplement. Wow. We're only 2 sentences in, everybody. We're only 2 sentences in. The government's PO'd. All right, here we go. The defendants reserve the right to seek adjournments of other aspects of the schedule, including the SIPA Section 5 and 6 deadlines and trial date, without acknowledging that their proposed schedule renders those dates an impossibility. Yet nothing material has changed since the court set the trial date. Because of a slightly longer than anticipated time frame for entry of the SIPA Section 3 protective orders and reading defense... Government's mad. Let's see what. Reading defense counsel into certain compartments, a timeline not controlled by the special counsel's office, the government would be amenable to a short extension for the defendants to submit a filing related to their theories of the defense in parallel to the government's October 10th, 2023 SIPA section submission. Instead, the defendants argue for a schedule that would delay even the initiation of SIPA Section 4 proceedings by over 3 months. Oh, that's awful. In doing so, the defendants, 1, misstate what is necessary to file an ex parte submission, setting forth general defense theories. 2, falsely accuse the government of delaying discovery. 3, unnecessarily propose overhauling the SIPA schedule, including by implementing responsive non-ex parte Section 4 briefings, even though that approach is foreclosed by the 11th Circuit's decision in U.S. v. Campa. And 4, make arguments about prudential searches and discovery obligations that are not relevant to deciding this motion, overstate the complexity of anticipated pretrial discovery litigation, and are meritless in any event. The current SIPA schedule should proceed apace with, at most, a short extension for defendants' ex parte filing. Ooh. Argument number 1, the defendants are presently able to set forth defense theories in an ex parte filing. Sub A, the defendants misstate what is necessary for their filing. Oh dear, you don't ever want to hear that. In asking for a 3-month extension to present ex parte their theories of the case, the defendants overstate that their filing will entail and what their filing will entail and the discovery necessary for them to accomplish it. The defendants already have more than sufficient discovery to provide the court with a description of the type of information they consider relevant and helpful. The defendant's motion can and should be denied on this ground alone. All right. Oh, here we go. I'm a little worried. I'm worried. They always misstate. They do. They misstate and they use incorrect law a lot. We'll see if that happens here. Defendants correctly assert that courts routinely permit defendants to make parallel ex parte submissions describing their defense theories. Courts have allowed the defense to provide their own filings in order to outline their theory of the defense to aid the court in its review of the classified material. The district court also conducted ex parte hearings with defense counsel to learn about their defense theories and how any classified information might be helpful or necessary to the defense. But neither of these cases nor any cited by the defendant supports the argument that classified discovery needs to be complete and reviewed in its entirety or anything close to that before the defendant can outline their defensive theory. So he's citing the Maui case. Defense counsel proffered theories without having reviewed any classified information. They did not have security clearances because no classified information was deemed discoverable. All right. Consideration of the charges the defendants face illustrates the point. Trump is the only defendant charged with mishandling of classified information. He's charged under Section 18 U.S.C. Section 793E with the willful retention of national defense information. To convict a defendant under this statute, the government must prove 3 elements. 1, unauthorized possession of the document. 2, that it related to national defense. And 3, by a defendant who willfully retained the document and failed to deliver it to the employee or officer entitled to receive it. So these are the 3 elements required to prove beyond a reasonable doubt for trial. Just FYI, if anyone's wondering what the test is. National defense is a generic concept of broad connotations, referring to the military and naval establishments and the related activities of national preparedness. Moreover, to qualify as national defense information, the information also must be closely held by the government. That is, national defense information is limited to, here we go, information that the government has endeavored to keep from the public, citing the Campa case here and a couple more cases. Potential defenses to the charge might include, for example, that Trump was authorized to possess the charged documents, that the subject matter of the documents did not concern the national defense. Is that better? Okay. Right. Okay, there we go. So, all right, better, good. So let's just for a minute, let's just highlight that the state is setting out what defenses the defendant could use. Let's just note that. Potential defenses to the charge might include, for example, Trump was authorized to possess, here's the first defense, the charged documents, that the subject matter of the documents did not concern national defense. Here's the second defense, that the documents were not closely held. There's a third defense. Or that he did not willfully retain the documents. Seriously, they just gave him 4 defenses. The defendants can outline in an ex parte filing any theories on which they may intend to rely, and a detailed inspection of all discovery is not necessary to do so. In light of the level of detail in this superseding indictment, the defendants here are arguably adequately equipped to outline a defense theory before receiving any discovery at all. and, as further discussed below, even more so because of the extensive discovery provided to date. Ooh, goodness. So, moreover, as further explained below, the government will be using SIPA Section 4 in this case largely to obtain this court's authorization to provide classified information to the defense in the form of substitutions and redacted documents rather than withhold it entirely. The nature of the material the government will propose substituting and the limited redactions it will propose are unlikely to require finely detailed defense theories in order for the court to determine the helpfulness of the material or the adequacy of the situation. So, Patty, yes. So what they're saying here is Trump is asking for 3 months in order to have more time for discovery because of the classified documents. The government's saying you don't need 3 more months and you can plead this out easier in an ex parte pleading rather than making a big production out of it. So that's pretty that's pretty much what's going on here. I don't know much, but when she says, "Ooh, goodness, it's serious." That's true. So, yeah, you're probably not picking up on the subtle sarcasm that the government is doing here. The government is basically saying, look, there's only 4 things you can do to defend yourself against this situation, and all of them can be done in less than 3 months. So you do not need your 3 months in order to proceed. Yeah, it's delay. It's more delay, right? Well, yeah, I don't know if she'll agree or not, but this already, they're like, look, we've just outlined for you all the defenses you could possibly use. And it's not going to take you 3 months. That's pretty harsh. The nature of the material the government will propose substituting and limited redactions it will propose are unlikely to require finely detailed defense theories in order for the court to determine the helpfulness of the material or the adequacy of a substitution. Of course, the court may, after reading the motion, ask the defense for a supplemental filing or hold an ex parte hearing to address any particular questions. Now, the government is telling the court what the court's job is. The court may not like that, but we'll see. All right, B. The discovery produced by the government is more than sufficient for the defendants to make their filing. The defendants falsely accuse the government of not making good on its discovery promises, but the accusations do not withstand scrutiny, and they try to not move the paper too much, provide no justification for delay in light of the substantial discovery the government has already produced, much of it months ago, as set forth in the September 14th of 2023 Joint Status Report, which, by the way, the defendant was not involved in. It was only the government. The government has made 5 productions of unclassified discovery totaling 1.28 million pages, including all of the witness memorialization, interview recordings and transcripts, grand jury transcripts, and FBI 302s in the government's possession as of its most recent September 1st discovery production, and all of the CCTV footage acquired in the government's investigation. And then we have an end note here, so let's bump down and see what we're talking about with this end note. Notably, the government's largest production of unclassified discovery, including well over half of the unclassified discovery produced to date, was its first production, which defendant Trump has had since June 21st of 2023, 2 days after the entry of the protective order in this case, and the other defendants received within a day of entry of an appearance by counsel. So that's pretty good. The witness memorialization produced included about 200 unclassified transcripts of witness interviews or grand jury testimony. Here's another end note. Let's bump down. As set forth in the Joint Status Report, which again was just filed by the government will later produce agent communications that are Jenks Act material for testifying agents, but as reflected in the standard initial omnibus order entered in this case, Jenks Act material can typically be produced up until the morning of the first trial day. The government's production here, months before a defendant's Section 4 submission, is due, and many more months before trial, of some 200 transcripts of witness interviews and grand jury testimony, only enhances the defense's ability to make their Section 4 submission, well beyond that of most defendants. Among the extensive materials that the government has provided to the defendants are transcripts of the summary agent's testimony in the grand jury and all accompanying exhibits. The defendants' suggestion that they have been hamstrung from timely outlining their defense based on whatever additional Jenks Act material remains to be produced has no merit. And then back up. With respect to classified discovery, on September 13th, the date of the court's entry of the Section 3 protective order, the government produced the majority of classified discovery it anticipates producing, and nearly all will be produced prior to the government's current Section 4 deadline. For example, on September 26th, the CISO placed in the defense SCIF the remaining classified witness interview transcripts, and all classified witness interview transcripts are now in the defense SCIF. So within the ability of the defense to look at. As the defendants are fully aware, but omit from their pleading, the reason for defense counsel's inability to fully review the September 13th production is they lack all of the necessary read-ins. But this was not a failure by the government to make good on its promise to produce the material around September 12th, nor any other failure of the government's part. The timing of the defense counsel's read-in is not controlled by the special counsel's office. The government has recently been informed that multiple defense counsel for Trump now have necessary read-ins to review all material in the government's September 3rd production, with the exception of a single charged document and several uncharged documents requiring a particular clearance that defense counsel does not yet possess. The government understands that the presence of these documents in the set of discovery available in the defense SCIF in Florida and prevented the defense from gaining access to a safe containing a subset of classified discovery where the defense reviewed the majority of the September 13th production during the week of September 18th. On September 26th, at the government's request, the CISO removed the documents requiring the particular clearance from the safe so that the remainder of the subset would be fully available to Trump's counsel. Accordingly, most of the defendants' complaints, such as their complaint that they've not been able to access 16 of the 32 charged documents, have now been resolved. Wow. So defense is stating we haven't been able to get to the documents. Government's saying because you didn't get clearance and that's on you. But now you've got clearance and we sorted everything out, so now you've got full access. So quit complaining. That's kind of what's going on here. Yes. Yes. Oh, here we go, everybody. Sorry about that. It's Florida. There we go. Okay. Oh, absolutely. Absolutely. Got it. We got it. Everybody get it? Now there's my summary. You didn't get your clearances. The government's like, that's your problem. And they're like, well, fine, we got them now. And the government's like, fine, now you can see the documents. We're done. And then we'll bump down here. The government stated at the September 12th hearing that there were 5 charged documents that the defense SCIF is not currently authorized to store. The owners of 4 additional charged documents have since requested that those documents not currently be stored in the defense SCIF, and as a result, on September 26th, the CISO removed those documents from the SCIF. So I think there's some pretty significant trust issues here going on in this situation. The government understands that the CISO is working expeditiously to find a location in Florida that can store these 9 documents. Defense counsel has the necessary read-ins to review these documents, and in the meantime, these documents can be made available in Washington, D.C. area for defense counsel's review at their convenience with the court's permission. So the government is saying, okay, look, I get it. These 9 of these documents aren't available to you because your security protocols aren't as high as they need to be, but they are in DC if you want to take a look at them. That's what's going on here. No, Emily. No, an average Joe would not be catered to at all in this way whatsoever. And, another thing that I think is worth noting in this situation is if you look at how complicated these procedures are for defense to look at these documents that he's been charged with possession of, there are so many hearings and so many protocols, and yet he just had them lying around, right? Is anybody else getting that from this? Like, look at how much work he has to go through to look at them now, because of the level that they were classified at. And he's like, look, we can't get access. Meanwhile, he didn't give them back when they requested it. And he said, I can have all these documents myself. Meanwhile, trying to even look at them again, he has to go through all of these protocols, which is required by law. Kind of rhetorical. Yes. I felt it was. It's terrifying how careless he was. Yes, exactly. I mean, have you noticed? I mean, he's complaining. He's saying, look, not everybody had gotten high enough security to be able to see these documents. And even the place to hold the documents isn't secure enough for him to go and see them. And so they have to be in Washington, D.C. And meanwhile, these documents were just spilling out of boxes on his property. Exactly. Why did he even take them out of the White House? Yeah, I mean, again, initially, sure, we can have some mix-ups. I get that. But then when they're saying, look, we need our stuff back, and he's like, you're going to have to wait until I find the time to go through the boxes. And they're like, we can't. And, that's why he's been charged. So it's a lot. Yes. He needed someone to read them to him. That's funny. That's so funny. Yeah, I just think it's really ironic that defense is saying, oh, we can't get access to these documents, so we need more time. Meanwhile, it's like the whole case is because these documents should have been protected. Oh. All right, so I digress, but I think it's a valid point. So here we go. By October 6th of 2023, as suggested by Defense Counsel, the government will also provide the remainder of the previously identified classified discovery, aside from one, a small volume of classified Jenks materials, primarily agent emails. Now let's look down here again. We want to make sure we follow here. Should the defendant seek to notice any of the materials under the SIPA Section 5, the government would not oppose their doing so in a supplemental notice due to the later date of production. Again, this is all just fancy language for these documents have to be protected, and there's special hearings and protocols you have to do in order to see them. So that's what the government's saying here. And 2 items that will need to go through the SIPA Section 4 process prior to production. This production will include certain materials the defendants have described as outstanding, including audio recordings of interviews and information related to the classification reviews conducted in the case. Again, based on the purpose of the defense filing and the limited nature of the government's anticipated Section 4 filing, none of this additional discovery is needed for the defense to set forth generally their theories of the defense in order to aid the court's ex parte review of the government's Section 4 filing. Nonetheless, the government is amenable to a short extension for the defendant's ex parte filing. So the government's saying, yeah, you can have a little bit extra time if you need to for your ex parte filing, although we don't really think you need it, but if you really feel like it, sure, that's fine. So next, 2, the court's current schedule correctly sequences SIPA proceedings, and defendant's requested overhaul of the schedule is unwarranted. So, again, Classified Information Procedures Act. So let me just take a minute here, all right? SIPA is a law explaining how these documents need to be handled, okay? So what they're saying is under Section 4 of the SIPA Act, there's certain hearings and protocols that need to be followed for some of these documents. So that's what we're talking about when I'm saying SIPA Section 4, okay? The SIPA Section 4 deadline appropriately comes early in this court's scheduling order. Defendant's motion not only requests an extension for the ex parte filing. Now, again, an ex parte filing means just that they don't have to talk to the government about it. They can just file it with the court. So just one party filing, but also proposes overhauling the entire schedule in this matter. The resequencing of events proposed by the defendants set the schedule backwards and would intentionally derail both pretrial proceedings and the court's trial date. As government explains to the defense during a meet and confer session on this motion, a ruling on the government Section 4 motion is a prerequisite to producing certain discovery in this case. Again, there's this handful of documents that have to be follow the Classified Information Procedure Act in order for anybody to see them. All right, so that's what they're talking about here. Pursuant to SIPA Section 4, the government may delete specific items of classified information from documents, substitute a summary of the information for such classified documents, or substitute a statement admitting relevant facts that the classified information would tend to prove. Therefore, not only permits withholding items from discovery, but it also is a mechanism to obtain the court's approval to produce classified documents with redactions or to provide substitutions to the defense. This means that the government can redact certain parts of the classified documents because, again, these documents are property of the United States. So even though the defendant's been charged with them, he does not have a right to see them. He has to go through the proper hearings and protocols in order to see them. As indicated in the defense, the government intends to use SIPA Section 4 in that manner unless and until the court authorizes the government to produce certain classified documents to the defense with its proposed redactions, or in a substituted form, the government cannot produce the documents at all. And then we have an endnote here. Some of the very material the defendants complain in their classified supplement of not having received cannot be produced to them until the court rules on the government's Section 4 motion. So now they're saying some of the stuff you want, we'd like to give you, but we have to wait until the court determines it. The current SIPA litigation sequence, which began with the government Section 4 filing, is therefore logical. It allows the court to resolve the government Section 4 motion and the government to provide additional classified material to the defense before the defendant's November 17th Section 5 deadline. We should have Trump trial bingo cards. We should. Section 5 deadline to notice that the classified information the defendant reasonably expect to disclose or cause the disclosure of. On the other hand, the defendant's proposal would delay by at least 3 months the production to the defense of certain classified information that the government intends to produce subject to certain protections, assuming the court authorizes them through Section 4. If the government does not file its Section 4 motion until next year, the Section 5 proceeding would not commence until later. In 2024. During a meet and confer session on defendant's motion, defense counsel acknowledged as much, yet their filing is silent as to when subsequent SIPA proceedings would take place, as well as the inevitable delay in the trial date that their request would require. Their filing, therefore, though purporting to concern the Section 4 schedule, seeks to relitigate their previous attempt to consider indefinitely the trial date in this matter. The court should therefore withdraw the current order setting trial and postpone any consideration of a new trial date. The defendants misleadingly cite cases where classified information was not necessary to prove the charges in